Good evening, everyone. I'm going to call the Rights of Way Subcommittee meeting to order. This is the State of Rhode Island Coastal Resources Management Council. Today is Tuesday, November 12th, 2024. This is in the matter of Spring Avenue. First matter we have on our agenda, well, I'd ask that the record reflect the council members, the subcommittee members that are present, as well as staff members that are present here this evening. Our first matter would be approval of the minutes for the October 8, 2024 meeting. They have been disseminated. I would ask for a motion to approve these minutes. Motion made by Mr. Gagnon. Is there a second?
Second.
Motion made and seconded by Ms. Reynolds. All in favor, say aye. Aye. Anyone opposed? Motion carries. Any staff report, Laura?
Mr. Chair, no staff reports at this time.
Okay. Get back to hear and decide the remainder of the motions and objections filed by the parties for the matter of Spring Avenue right of way, CRMC file number 2020-11-084. Turn it over to our attorneys to continue to conduct the matters.
Okay, as you may recall, at the last meeting that we had, this is all for pretrial motions. And we had started with the motions that had been filed by the Weekapaug Fire District. Mr. Farside, if my notes and the notes of the chair are correct, the last motion dealt with was to compel the deposition testimony of expert witness Joseph A. Priestley Jr., correct?
That sounds correct to me, Counselor. And if you'd indulge me, I think we can dispense with a number of the pending motions as moved or having otherwise been addressed since the last meeting occurred, so that we can cross those off our list before moving forward today, unless you'd rather do it a different way.
No, not at all.
Okay. The first one on my list that's been rendered moot is the town of Westerly's motion to depose the Weekapaug Fire District. That deposition has occurred.
Mr. Conley and.
Yes, that's correct.
Okay.
That's one less that needs to be heard tonight. The next motion that's been rendered moot is Ms. Contrada's motion to subpoena Waterman Engineering. The fire district this morning produced additional paperwork related to a survey produced by Waterman Engineering and have reached an agreement with counsel for Ms. Contrada on the authenticity of the subject survey and the transmittal letter while reserving all of our other rights. So Ms. Contrada's motion for a subpoena to Waterman Engineering has been rendered moot.
Yeah, that's correct. I'm relying on the representation. There won't be any objections to authenticity. I understand there could be objections as to hearsay, concerns about accuracy and so forth. But as to authenticity, my understanding is there's not going to be an objection at hearing. And with that, that motion is moved.
Is that correct? As to authenticity?
That's correct, as to authenticity. The next motion that we suggest has been rendered moot is Ms. Contrada's motion to compel a title report authored by the late Calvert Groton. That title report was the subject of a privilege determination. But upon further investigation, the privilege no longer applies, and that document has been released as of this morning to Ms. Contrada's counsel.
I just found out sitting here that there was such a transmittal this morning. I hadn't caught up on my emails in the interim, so I'm trusting in Mr. Farside that based on what his representations, yes, that would be moved.
Any others?
Yeah, one other, council, is the Rhode Island Attorney General's motion to compel more responsive answers to interrogatory and request for production that they propounded upon us, the fire district. We objected to that motion on October 31st. And, but we nevertheless went ahead and produced an additional, I don't know if this is 200 or so plus pages of additional material to the Attorney General this morning, and serve supplemental interrogatory responses, which we contend renders the motion to compel moot at the very least, and understanding that the Attorney General's office has only had a few hours to look at the material. At the very least, they should take their time to look at the material and advise us if they see any continuing deficiencies to which we can respond at that time. But our position is that the motion is rendered moot.
The AG's office would like time to review these documents just to be sure, and we would ask for a continuance if possible.
I'm sorry, could I have your name, please?
Randall Boots for the Rhode Island Attorney General's office. Thank you.
Perhaps we should have all the, we're familiar with all of you, but perhaps for the record purposes, we should have the council identify themselves.
Sure. Joseph Farside for Weekapaug Fire District, and I'm here with my colleague Natalie Vega.
Sarah O'Toole for the town of Westerly, and also with me is William Conley.
Michael Rubin for Caroline Contrada.
And again, Randall Boots for the state of Rhode Island and with the Attorney General's office, and with me is Rachel Rivella.
Okay, so that leaves, are there any others?
No others that are moved, and in our opinion, there are a couple that are not objected to or unopposed. I don't know if you want to tackle those first.
I have your motion to exclude late disclosed witnesses.
Yes, that is opposed.
That was the next one on my list.
Okay,
Are there ones that are unobjected to?
there are. So one that's not objected to is the fire district's motion to issue a subpoena to Marcia Anderson Fisk.
If I may, I did not object to that motion and don't object to it in principle. I have never talked to the witness directly. But I understand that she's Westerly based and would probably prefer the deposition be in Westerly. So out of comity or courtesy to the witness, I would like that be understood. She might be a snowbird and might become unavailable during the winter months. I wouldn't want to see this hearing necessarily delayed. Obviously, she might agree to a video deposition or whatever, and we certainly wouldn't do anything to obstruct that, but I wouldn't want to see us getting delayed to next spring just because this witness is unavailable being out of state. But other than that, I certainly have no objection to principle. And other than that, I have no objection.
Ms. O'Toole, any objection?
No, the town has no objection.
The state has no objection.
Ms. Anderson Fisk was disclosed by Ms. Contrada as somebody who had knowledge of using the Spring Avenue extension, or who has used the Spring Avenue extension in answers that she served at Discovery back in June of this year. Ms. Contrada also mentioned Ms. Anderson Fisk as somebody with knowledge during Ms. Contrada's deposition. For those reasons, we wanted to depose Ms. Anderson Fisk.
Would the committee like to take these uncontested matters up individually now?
What's your recommendation?
I think just to move things along,
Sure.
yes.
And this is actually the only remaining one that's unobjected to. I thought there was more than one, but this is the only one that remains unopposed. The remainder on the list are opposed.
So you need a motion to,
Grant. Based upon the fact that there's no objections.
CRMC to issue the subpoena.
Yes. You want a subpoena issued by the agency?
That's correct.
Yes.
So move that.
Your motion's been made. Is there a second?
Second.
Motion made and seconded. I'll now pull the council, the subcommittee. Ms. Reynolds,
Yes.
Mr. Gagnon.
Yes.
I, Raymond Coy, vote aye. Been approved.
Although I'm not so sure you need a motion on this. You do have the four motions that were cited by Mr. Farside. And that was the motion for the town of Westerly. It's already been taken care of for the Weekapaug Fire District. And the motions by Ms. Contrada for the Waterman survey and to compel the title report. And finally, the Attorney General's motion to compel the request there is to continue it to give time for the Attorney General to review documents that were supplied just today.
You make the motion.
I'm going to suggest that you pass, just have a motion to pass the first three motions and grant the continuance to the Attorney General. How much time do you need, Ms. Boots?
We would ask for 30 days.
30 days.
So move that the first three be completed and that the Attorney General's motion for continuance for 30 days be granted.
Proper.
It's proper.
Okay. Is there a second?
Second.
Motion made and seconded. I'll now pull the subcommittee. Ms. Reynolds,
Aye.
Mr. Gagnon.
Aye.
I too, Raymond Coy, vote aye.
Okay. So we're back to your motion to exclude late disclosed witnesses. That's the next one I have on the list. I don't know if that's what you have on yours.
It's on my list. I might suggest, though, that we proceed first with, I realize I'd be taking things out of order, that we proceed first with the Attorney General's motion to quash the notice of deposition that was served upon it. I think that the disposition of, well, the two aren't entirely related. So let's proceed with the fire district's motion to exclude Rhode Island Attorney General witnesses. This is our motion to exclude witnesses who were not disclosed to us until August the 1st, which, if you recall, there was a mid-June deadline for discovery in this case that the subcommittee set at a meeting in the spring. These witnesses were not disclosed until a month and a half after that deadline. We actually went ahead and already deposed James Angelo, one of those two witnesses. But the second witness, Cassius Spears, has not been deposed. And we're concerned about the Attorney General's office continuing to add witnesses, even after fact witnesses, even after discovery should have closed, according to the subcommittee. We did seek through interrogatories more information about the testimony that Mr. Spears would give. But the Attorney General's office refused to give us answers to those interrogatories, which is why we separately moved to compel. We actually proposed an agreement this morning to resolve this motion and our motion to compel answers to interrogatories. And what we had proposed was that if the Attorney General's office would answer our interrogatories relating to three witnesses who were disclosed after the mid-June cutoff, that we would, and agreed not to propose new witnesses yet, that we would go ahead and move forward with accepting those witnesses and deposing them. But that agreement was that proposal was turned down. So, you know, these are not existential issues to the case, but raise matters of fairness and prejudice. And either we want the witnesses to be excluded, or we want to have the Attorney General's office answer basic interrogatories for us about what these individuals know, so we can evaluate and then go ahead and depose them.
Are we arguing both of these motions?
Just the first one.
Just the first
We'll
one?
take the second one up afterwards.
Okay, great. So these witnesses were disclosed within days of the Attorney General's office, even learning their names as relevant to this case. And there is no undue prejudice, as there's not even a hearing scheduled yet. And respectfully, the fire district can pick up the phone and call the witnesses. They have their contact information. Further, the parties, including the state, have reserved their right to supplement the witness list. And we did, in fact, say that we were not going to settle on this matter because the settlement or the agreement offered was essentially what we would get if we lost the motions anyway. So I do want to emphasize the AG's office acted as quickly as possible in disclosing these witnesses. We take the witnesses as we find them. We couldn't have done anything more to identify them ahead of time. And again, we disclose them as quickly as possible, and there's no prejudice here. Thank you.
Thank you. The Attorney General's office has not disclosed contact information for these witnesses. If they are so inclined to do so, we'll go ahead and reach out to those witnesses on our own.
Ms. O'Toole,
The town hasn't taken position on this motion.
Mr. Rubin.
We haven't taken a position formally. We didn't file anything, but I do support the objection, especially with regard to Paul Yema. The name Paul Yema did come up some time ago. Attempts were made to contact him. He was a very difficult person to reach. And apparently he had very crucial family health issues with his wife being in extreme condition. I don't know what her fate has been since. And he essentially refused to talk to us. But apparently he's plus he's an extraordinarily busy gentleman. He's apparently an established businessman and I believe an engineer who has many work commitments. So he was extremely hard to reach. Eventually, the Attorney General's office was able to reach him after my client was unsuccessful. He is a very well-published amateur fisherman. Apparently, he has written articles and even books about fishing. Apparently, he's, I think is a person who carefully documents his fishing spots and so forth. And I think from what I know about him, second or third hand, he would be a very credible and valuable witness. And so therefore, I think that the deadline that has since passed can be waived by subcommittee in this case, given the value of his prospective testimony. I would also add this, obviously, both sides of this case are entitled to present their cases and do so fairly. But there is an advantage to the fire district whose residents are there, concentrated, contactable. People who might have used the path might have done so intermittently, maybe casually, maybe only one time, and are now scattered to the four winds. So we're under a disadvantage. And so while I support the objection altogether, I especially support it with respect to Mr. Yema. And also apparently he was just recently hospitalized, and that's why his deposition hasn't already taken place.
So if I may, just to crystallize, if we're able to receive a supplement from the Attorney General's office to their response to our discovery, providing the contact information for these witnesses, we'll agree to take on to contact them on our own, and potentially schedule their depositions, subject to noticing the other parties as a way to resolve this issue.
We would be able to provide the contact information that hasn't already been provided that we have in our session.
So the formal motion by the subcommittee would be to deny the Weekapaug Fire District's motion on the condition that the witnesses that are on their list that came in after the deadline, that their contact information be supplied to the Weekapaug Fire District.
Or in the alternative, to approve their motion to exclude those witnesses, correct?
Yes, but
Because they weren't provided at a date, by the date certain.
that's correct, but I have to say that Ms. Boots does raise a good point. Typically, these deadlines are in place, a discovery order is in place so that there's no undue prejudice, so that parties to a matter are not surprised going forward. In this instance, there is no date for a hearing on this. And I think that's one of the reasons why Mr. Forsythe is saying, so long as we get the contact information, we'll make the analysis ourselves.
Okay. Is the committee in a posture to make a motion?
I'll do this one. I make a motion to deny the Weekapaug Fire District's motion on the condition that the witness information, contacting information, be provided to the fire district.
Is there a second?
Second.
Motion made and seconded. I'll poll the subcommittee. Ms. Reynolds,
I,
Mr. Gagnon. I too, Brendan McCoy, vote aye.
Thank you. Mr. Forsythe, I think we've gotten all of your motions.
I think that resolves both the motion to exclude witnesses and the motion to compel answers to interrogatories. Let me just ask. Right, okay. So that does resolve the fire district's motion to exclude attorney general witnesses. We do still have the motion to compel answers to interrogatories, and one interrogatory in particular that I can focus the subcommittee on, if that's okay. So once again, this is our motion to compel intervener, Rhode Island Attorney General, for answers to interrogatories. And there's an interrogatory that specifically states, state with particularity the reasons why RIAG decided to intervene in the above captioned CRMC proceeding, along with any legal basis RIAG believes it has for doing so. This is Exhibit C to the motion, and it's on page 4. This is request interrogatory number 8. The response to that very straightforward and basic question is, quote, objection. This information is not relevant within the meaning of Rule 26 and calls for information protected by attorney-client privilege, common interest privilege, deliberative process privilege, and work product doctrine. Further, this request is unduly burdensome, vague, broad, and not limited in time or scope. Now, let me just repeat the question. State with particularity the reasons why the RIAG decided to intervene in the above captioned CRMC proceeding, along with any legal basis RIAG believes it has for doing so. Now, we believe the district asserts that's a very basic issue that we're entitled to have information on. The Attorney General's office has sent a letter to this council late in 2022, urging it strongly to adopt the Spring Avenue extension as a public right of way. has intervened formally in this matter. It's not just serving as somebody's counsel, it formally has intervened in this matter with the hope of pushing this council, this subcommittee, towards finding of a public right of way. And it really calls into question the integrity of the process when a question that goes to the essential decision of the AG's office to intervene here. And we are told that the request is unduly burdensome, vague, broad, and not limited in time or scope. If all the information is covered by privilege, then we need to be provided with a log that explains that. Otherwise, we should have a response to this question.
Respectfully, we have provided a privilege log that has 16,000 unique documents. So first and foremost, we have provided a privilege log that goes back to the date that we were asked to look into this matter. If I may, Rule 26. States that a party may seek only discovery that appears reasonably calculated to lead to the discovery of admissible evidence. The Attorney General and the Attorney General's staff and attorneys working under him, our deliberative process is, first of all, not relevant. And second of all, it is protected by the investigative and deliberative process privilege, which protects information or documents reflecting advisory opinions, recommendations, deliberations comprising part of a process by which governmental decisions or policies are formulated. That's a United States Supreme Court decision. The Rhode Island Attorney General's office is able to make decisions and is able to deliberate under protection, of course limited, but in this situation, this subcommittee had already had it on the radar, and it was already referred to this subcommittee, the Spring Avenue right-of-way matter, by the time the Rhode Island Attorney General had even heard of Spring Avenue and that there was an issue over it. So respectfully, not only does the deliberative process privilege apply, but so does the work product privilege, which there are two work product privileges. First is opinion, which includes the attorney's mental impressions, opinions, legal theories, and conclusions. The second is fact work product, which protects work product that was prepared or obtained because of the prospect of litigation. Again, this was already referred to the right-of-way subcommittee by the time the AG's office even found out about it. So work product privilege also carries here. And finally, the Rhode Island Attorney General's office is somebody's counsel. We are the public's counsel. We are the people's attorney. And I do think that that is something that is important to consider. Thank you.
But before you say anything, Mr. Farside, Ms. Boots, if that's the legal basis for the intervention, was that part of the answer?
The legal basis, I don't think that we need to disclose the legal basis for our intervention because I do believe that it is protected by work product privilege and by deliberative process privilege. I did just want to, because he had stated that we didn't have a client, and we do, the public is our client.
The answer relies upon attorney-client privilege, common interest privilege, deliberative process privilege, work product doctrine, basically the kitchen sink of excuses for not answering a basic question. But then it says, further, this request is unduly burdensome, vague, broad, and not limited in time or scope. So either they're withholding information from us on grounds that this straightforward and easy to understand question is unduly burdensome, vague, broad, and not limited in time or scope, or they're not. So if they're not, then they should amend their answer to eliminate that phrase, and then they'll wholly be resting under the attorney-client privilege and its corollaries that they believe applies, which we do not, and we can at least move forward with an understanding of how they're responding to this interrogatory.
Ms. Boots said that, a privilege log, extensive one, was submitted.
We do have a privilege log.
Okay. Thank you. Thank you.
Thank you.
Need a posture for a motion? Questions of our attorney?
Any questions?
Yes. So what are we looking for here to just state that the Attorney General's office is allowed to intervene?
No, the question rather is whether or not the Attorney General should be compelled to answer a question to an interrogatory as to what's the basis for their intervention and how they came to the decision to do that. And the Attorney General is a lawyer, and the staff is by and large attorneys. And I think that's what Ms. Boots is relying on. And we've had other matters where the Attorney General has intervened in cases where CRMC is a party to represent public. So I think that's the factors you have to take a look at as to whether or not this motion should be granted to compel the Attorney General to disclose reasons as to why they came up with a decision to intervene and what's the legal basis for the intervention.
What's a privilege log?
Yeah, when I give advice to you all, that's protected under the attorney-client privilege, and it's not discoverable under the rules of evidence for courts. It's also not discoverable to the Access to Public Records Act. What you're supposed to do when a question comes in on an interrogatory or even an APA request, you state that you're not going to answer it based on whatever privilege it is, in this case, the attorney-client privilege. And then you're supposed to produce a privilege log, which references the documents that are being withheld. That allows the opposing party to go to court and to say, look, you should compel the disclosure of these documents. And then the reviewing court can take a look at it in camera to see whether or not they should.
So if we agree with the Attorney General's position, we would
Deny.
make a motion to deny.
Correct.
Fire district's motion.
Correct, yes.
So I make that motion, that deny the fire district motion. Additional information.
Motion's been made. Is there a second?
I'll second that.
Just some discussion, if I could ask. What's like the precedent on it? What's controlling law on this?
Well, actually, I have to say, both lawyers did a very good job in explaining their positions on this. This comes up quite a bit on it. The question is what type of a privilege appertains here? And as Ms. Booth said, I'm sure there were internal discussions among the lawyers involved in this thing. The question is whether or not that should be disclosed. The Attorney General is saying, no, it's privileged.
They're saying it's privileged why we got involved in this case.
That's correct, yes.
If I just made one quick remark is to.
Okay.
Yeah, it's fine.
Okay.
He's gonna say it anyway. He can't stop him.
This is not a situation where the Attorney General's office is acting as counsel to CRMC. They are an intervener an intervening party. They asked to intervene as a party. So from the fire district's perspective, that postures them very differently than if they were serving as counsel to CRMC in a court proceeding, for example.
That's correct, and that's actually happened in other cases where the Attorney General has intervened in the case on behalf of the public. And as Ms. Boots pointed out, the Attorney General is the attorney for the public at large on this thing. Mr. Farsight's correct. Ms. Boots says, yes, but we're here for the public. So she stands in the same shoes as Mr. Rubin or Ms. O'Toole and Mr. Conley. Or even Mr. Forsythe and Ms. Vega for their clients.
If, still in the discussion, so if a party, in this case, the Attorney General, invokes a privilege as to their involvement, why they're involved in the case, is that not prejudicial to the other parties in their questioning process and the mode of questioning?
You know, the ultimate issue here is whether or not the Spring Avenue extension is a right of way. So at best, this is an ancillary issue.
All right, a motion's been made and seconded. To
Motion to deny
deny
the motion.
the motion. I'll pull the council, the subcommittee. Mr. Gagnon,
Yes,
Ms. Reynolds,
I,
I vote no.
Is that it for you, Mr. Forsythe?
We have one more, actually. Fire District's motion to issue a subpoena to Ellen Kane. You have that one?
Oh, we did that one. No? Okay, sorry.
No, I wish we did. Ms. Kane is an individual who appeared in a PBS interview that aired in the summer. And Ms. Kane, before that interview, was unknown to us. She appeared in that interview and stated many facts as to the Spring Avenue extension public status. She's heavily involved in advocating for public access in various governmental fora. The district is entitled to discovery on where her knowledge and facts came from and whether she may have any additional knowledge. Of course, we have objections from the town and Ms. Contrada arguing, as they have in the past, that the district is just trying to threaten depositions, intimidate and silence witnesses and deter proponents. We're actually giving proponents a forum to come forth and be heard in a formal deposition setting. We note that the PBS interview featured, to my memory, no one else on behalf of the proponents besides Ms. Kane. And therefore, we want a subpoena to depose her and find out what she knows. We're a bit mystified by the objections to the subpoena. So with that, I'll turn it over to Mr. Conley.
I think I'll begin by noting that that's the first time I've ever heard anyone characterize somebody being subpoenaed to a deposition as somebody getting excited about the opportunity to promote their position on something. We all know how lay people feel when they are served with a deposition and they are unrepresented. We all know how lay people react when they show support for Ms. Contrada, they advocate for public access, and then are suddenly contacted by lawyers saying, we're interested in deposing you. Not something people generally get excited and joyful about. Now, I know the committee has read our objection and the exhibits appended to it, so I'm not going to just repeat it all for you. I just want to summarize the salient points. Ellen Kane is a shoreline activist. In fact, the district themselves acknowledge in their proposal to depose her that they want to depose her because she is actively engaged in other related shoreline access advocacy efforts on social media and government forums. So because somebody is engaged as an advocate on other matters, why would we want to take everybody's time and depose her in this specific case? They do say that it's purported that Ms. Kane has substantive knowledge of the SAE dispute. That's a spring habit. Now, it's clear from the video and the article that is related to the video and that was appended to our motion that as much of an advocate as Ms. Kane may be, she has absolutely no new or firsthand information about Spring Avenue. There is nothing in that video that would suggest that it's necessary for all these parties to take time to prepare for a deposition, to attend the deposition. The town is not going to call it as a witness. The intervener is not going to call it as a witness. The state's not going to call it as a witness. Nobody intends on calling this person as a witness. It's really not necessary to these proceedings to depose Ms. Kane. Don't represent her, but it's really unfair to somebody who simply wants to publicly advocate for shoreline access to be singled out as a deponent in a matter in which she has offered no information in a video or nor new or unknown information in a video or on a social media or otherwise. We simply object as a matter of really general fairness and efficiency to this process. Thank you for listening.
Very little to add. You know, the town briefed it, we briefed it as well, the town more thoroughly than me. So I more or less piggyback on the town's brief. I was aware of this person prior to this motion and prior to this video clip from PBS. But I was aware of her as a person who went to, who appeared at various town meetings of the town of Westerly and voiced opinions, not facts. And in this video, my surmise is that she essentially more or less largely a point voices opinions, not facts. And a citizen can have an opinion. Anybody who reads the Westerly Sun or the Providence Journal might form an opinion about this case. But that doesn't mean that they have substantive facts. Now, during the video, she did produce a real estate plat. It's, I can guarantee you, will be evidence in this case. And we're going to have title attorneys. They're going to have a title attorney. We're going to have a title attorney. The town might have a title attorney. They're all testified as to this plat. She gave her surmise of what this plat means. I doubt that she has, that she went, she's not a title attorney. I doubt that she went to town hall and found it herself. She obviously got it secondhand. So we're going to depose a person who's just a member of the community who found out some information secondhand about which we're going to have much better equipped persons to testify in the form of title attorneys and archivists and perhaps the town clerk. You know, I really don't see the point. So I see that this, the burden on a citizen who just advocates opinions is totally disproportionate to any kind of benefit that could be had. Thank you.
First, Ms. Boots.
We support the town and attorney. Thank you.
Yeah, this is not a random person. This is somebody who put themselves out there for an interview on PBS and appeared in a couple large segments in it and testified represented factual matters in that interview. So this is not a random person who might be bothered by requirement to sit and explain what she knows. My guess is that the proponents knew about this person and that she would go on to the news program before she did. So for those reasons, this is not a situation where we're putting somebody out. This is somebody who's actively involved, who's put herself out there in this matter, and we'd like to get to know what she knows.
If I may, just for the sake of completeness, I can tell you that we had no idea that PBS was gonna reach out to Ms. Kane and conduct this interview. Found out about it sometime after. Maybe even when I don't remember exactly, but maybe even when. Yeah, the fire district sent it to us. Yeah, that's when we found out.
Is there a commitment among the various parties that this person will not be a witness when the time comes for the hearing?
We have no intention of calling her.
No intention of calling her.
Ms. Boots?
She, if I could just add, she's not a person who, claims to have used the path or know people who use the path or has firsthand knowledge. The only knowledge she displayed, as I said before, was that she showed a plat that I don't know how she even got it.
Thank you.
Do we need a posture for motion
I'll make,
or any questions?
I don't have any questions. Do you have any questions? I'll make a motion to deny the request to subpoena Ellen Kane, finding the town and the objectors' arguments credible.
Second.
Motion made and seconded. Any discussion? Hearing none. I'll pull the subcommittee. Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
I too vote aye.
Any other motions from the fire district?
None others, no others. Excuse me.
No others from the town, thank you.
You don't have any motions pending?
I think that the only motions were the ones that were mooted out, as I recall.
All right.
I'll get rid of these guys first.
Okay, so you're all set? Mr. Rubin?
Yeah, I'm all set. I'm sorry. No,
Okay,
Nothing further, thank you, Mr. Chairman, members of the board.
thank you. Ms. Boots?
We have our motion to quash.
Okay,
So this is the AG's motion to quash the fire district's proposed deposition of the Rhode Island Attorney General representative. I want to start with saying that there is no prejudice by denying the access to a Rhode Island Attorney General representative, because all of the proposed subject matter pieces that the fire district would like to ask the Rhode Island Attorney General about have already been asked in written discovery, and the Attorney General's office has provided the extensive privilege log along with all relevant answers and objections. Additionally, deposing opposing counsel is sensitive and an incredibly disfavored means of discovery. It risks running afoul of privileges such as attorney-client, work product, investigatory, and common interest. Second, as I alluded to earlier, the written discovery that the fire district has propounded upon the Attorney General's office is substantially identical to what they're seeking in this deposition. The only possible purpose here would be to harass the Attorney General's office or impose undue expense to the office and the taxpayers of Rhode Island. The Rhode Island Attorney General's office did respond and object appropriately, as we went over earlier in this meeting, and have we have provided a 16,000 document privilege log. And there is no non-privileged information in the Rhode Island Attorney General's possession about Spring Avenue that the fire district has asked for or proposed in this notice of deposition that the fire district doesn't already have. They have everything that is unprivileged that they are asking for. And fourth, the legal authority does back up the Rhode Island Attorney General's position. As we briefed, the Woodland Manor test requires that the fire district must demonstrate that no other means exist to obtain the information other than by deposing opposing counsel. And again, they have propounded substantially the same questions in written discovery, which is the favored means of discovery, as they have asked for in Schedule A of this notice of deposition. And I'd like to end again with just stating there is no prejudice to the fire district here by not deposing the Attorney General's office. They have all of the information. Such a deposition would be a waste of their time and money, a waste of the taxpayers' time and money. And they won't obtain any new information that they don't already have. Thank you.
Attorney General's office has been evasive, to say the least, in its conduct in this matter since the time it sent its letter in 2022. We've gone back and forth. We even have APRA litigation ongoing that relates specifically to withholdings by the Attorney General's office of information, documents that the fire district claims it's entitled to. What we're asking here is for a deposition of an intervening party. Once again, it's important that the Attorney General here intervened in its own name. We are looking to depose the Attorney General on 6 topics: knowledge relating to use of the Spring Avenue extension to which you allege has occurred at any time, knowledge concerning the use of Spring Avenue extension other than by foot, knowledge relating to the basis for your decision to intervene in this matter. I'm paraphrasing here. Knowledge concerning your investigation regarding the potential designation of Spring Avenue extension as a public right-of-way. Knowledge relating to the basis for the letter I mentioned a moment ago. Knowledge concerning documents and communications in your custody or control that refer or relate to Spring Avenue extension. Ironically, what Ms. Boots's boss, the Honorable Attorney General, had said in a tweet was that that's what discovery is for in this matter. In other words, discovery would be the time when we exchange information, not the separate APRA litigation. Now it's time for discovery, and we wonder when we're going to have a chance to examine the Attorney General's office, an intervener in this case, on why it decided to attack the district's constitutional real property rights here. If this is what discovery is for, then it's time for discovery, and all we're asking for is a representative of the Attorney General's office who will sit with us and answer these questions. We do not seek privileged information. We're not seeking any information that's privileged. What we're seeking is information, not documents. We're seeking a witness who will tell us what basis they have for intervening in this matter and advocating for the positions they've taken, as opposed to looking at the evidence here as a whole and accepting that this matter is not open and shut as they said it was in their 2022 letter. The letter itself is very prejudicial to the district and its rights. We don't have evidence at this point that before the Attorney General sent that letter, that it ever conducted a legitimate investigation into the pros and cons. And that's what we want to get to the bottom of. That's what discovery is for. Those are the words of the Honorable Attorney General himself. And we submit we're at least entitled to a deposition of the Attorney General's office.
Just a quick question. This isn't a 32G. In other words, you're not asking for a keeper of records to come in for documents.
That's correct.
Okay. So who do you propose to depose on this?
any staff member that the Attorney General's office wants to put forth who can explain to us the investigation, if anything, they did before sending that 2022 letter, and explain to us what basis they have other than the documents they've given to us to date. And if there's nothing, then their witness can sit there and tell us there's nothing. But that's not what we've been told to date.
Where is the app for litigation at this point?
There is a hearing on cross summary judgment motions set for early December
In Superior Court?
before Judge Respallo, correct?
So yes, the Attorney General's office is both a party and legal counsel here. That is the unique position that the Attorney General's office holds. We intervene on behalf of the public. We conduct investigations. We find either, not in this case, but in other cases, bad actors, such as those polluting waterways like the Blackstone. We conduct our investigations. Those investigations are privileged for a very good reason. The Attorney General's office needs to be able to have those internal discussions of pros and cons without giving away the pros and cons to the other side that may be skewed. It is bad public policy to imply that the people's attorney does not represent the people just because they intervened individually as the Attorney General's office. Did you have a question?
Yeah, I do. Take your example, pollution in the Blackstone Valley. At any point, does the product of the investigation become discoverable?
Parts of it can, such as like documents that are not part of work product privilege. It's a very fact specific investigation at that point. However, in this case, all of the documents that we have that are related to Spring Avenue have been produced, and in that, or either produced or produced in a privilege log. That privilege log gives a summary of what the document is and what the document discusses while withholding the privileged information. Does that answer your question?
Is there a difference between a criminal investigation and a civil investigation?
There is, and I am not a criminal attorney, so I do not know the intricacies of a criminal investigation, but I would assume that, for example, if it was like a sexual assault case, that there may be stronger prohibitions on discovery due to the unique nature of a case like that, but I don't know the ins and outs of criminal.
Is there a difference between a civil investigation when pollution is a subject as opposed to this one, where the inquiry is whether or not it's a right of way to the shore?
I don't think so, because in both cases, it is the Attorney General's office working on behalf of the public. And there is a unique privilege. So for example, for attorney-client privilege to take place, that privilege is crystallized before litigation is brought. And in this case, the privilege with the Attorney General within our office, because we are the people's attorney, has been crystallized before we wrote that letter. That being said, litigation was already underway because this topic had already been referred to the subcommittee.
Is it work product or privilege in this case?
Work product doctrine, and it's a little bit of both probably. I also want to just get ahead to the question that Attorney Farside is saying is really crucial here, which is to state with particularity the reasons why the Rhode Island Attorney General decided to intervene in the above captioned CRMC proceeding, along with the legal basis the Rhode Island Attorney General believes it has for doing so. That's the same question that the subcommittee just said is privileged. And in terms of discovery, again, there are other avenues for discovery, and Attorney Farside has used those other avenues to get the most that he can out of discovery. That is written discovery. That is what is preferred when you are asking questions of opposing counsel. And all of the attorneys and staff at the Rhode Island Attorney General's office who have any knowledge of this matter are bound by privilege or bound by investigatory privilege, work product doctrine, and to some extent attorney-client privilege. So we would have to, I suppose, brief another attorney while also trying to withhold the privileged information. So it would get complicated as well. But the fact of the matter is that they don't meet the test that is required, that they are required to meet, that no other means exist to obtain the information. They have written discovery, and in fact, all of the questions that are listed in Schedule A, the topics that are listed in Schedule A, have been propounded upon the AG's office via discovery. Thank you.
We have propounded them, they just haven't answered them. The AG can't send a baseless letter to an adjudicating body like CRMC and then move to intervene as a party and later claim it can't be treated as a party and instead they're going to be treated as counsel. They may have to brief a lawyer to sit for this deposition. It might be a little complicated. That doesn't mean it's not the right thing to do.
Again, the questions that they are asking, I didn't bring it with me. I had it actually all laid out as to tying each individual piece of Schedule A to every request for production and every interrogatory. I would be happy to do that again and submit additional briefing to the council. They have all been asked in written discovery. This is a goose chase. It is at best, like I said, a form of harassment, and the AG's office has provided them everything and more. They have not provided us a privilege log. We have provided them a 16,000 document privilege log.
Thank you.
I
I was about to ask if Ms. O'Toole, Mr. Conley, and Mr. Rubin have anything to say.
The town of Wesley has nothing to add, thank you.
I would just add that I understand the scope of discovery is very, very broad. And it's not just relevant evidence, it's anything that can lead to relevant evidence. But what I understand and what I'm hearing here is an inquiry into motives and earlier decisions, not evidence regarding the right of way itself. You know, I'm not hearing, oh, maybe you got some plat someplace, or maybe you have a deed someplace, or maybe you have a photograph someplace, or maybe you have a witness. It's all about the thought processes and the motives and the intentions of the Attorney General's office, which would not be evidence one way or the other. They might be, you know, whether they're good or bad, they would not be evidence regarding this right of way. It's not as if the Attorney General, either they're inquiring, oh, do you know of any witnesses, or have you seen anybody go down there? Do you have some aerial photographs? It's all about the Attorney General's internal thought processes and deliberations. And it occurs to me that this is really secondary litigation, not about the underlying right of way itself, but about why we're here before you. In other words, what the motives and the interests of the parties are. And so let's get down to the business of the right of way. And this is what Mr. Farside himself said way back on over a year ago on June 28th, 2023, in front of this very forum. Quote, this is and I read elliptically, but I think fairly. Quote, this is a property dispute with a narrow statutory mandate. This is not a test case for shoreline access. This is an issue of property rights. This is part of CRMC's narrow statutory mandate. In other words, we're just fighting over a piece of land. And you know, as I said last time we were before you, people have been fighting over pieces of land ever since the time of Hammurabi in ancient Babylonia. And that's all it is. It's about the land.
You weren't representing Hammurabi at the time.
No,
All right, just checking.
I'm almost that old.
I know.
Thank you.
Well, you have, you've heard some very good legal arguments on this one. And I'm not so sure anything needs to be added at this time. This is a discrete issue. You've addressed it partially previously. If you have any questions, be happy to answer them.
Is it unusual to have a subpoena or a request for information that's not directed at somebody, but at a general office?
It's not unheard of. I had said earlier, a keeper of records. That's one type of a deposition where you don't know exactly who it is. Sometimes there are subpoenas for depositions for the person in an organization that has the most knowledge to it, and the opposing party doesn't know who that is. So it's not unprecedented.
And I do, in the list of the 6 items that Attorney Farside mentioned, I did also note the fact that one of them was already denied.
That's
Is there
correct.
an internal conflict now if we decide to do something different at this point?
Well, I think you're bound as to that one that's already been denied.
Is there any better information we'll get once the APRA hearing is completed and there's a decision on that? Will that impact this request?
Well, if the APRA appeal is granted for the Weekapaug Fire District, that would make this moot. I'm not sure what the APRA request is. I suspect it's for the same information. So that would moot this because the information would be disclosed. The Access to Public Records Act is section 38-2-1 of the general laws. It has its own rules on it, although it does relate to something. One of the exceptions is something that would not be disclosed in discovery in court. Is it relevant? Maybe.
So is there any harm in waiting until that decision is issued?
Well, we're in mid-November. The hearing is when?
First week of December.
First week in December. You've got 30 days for the Attorney General to review documents that have been disclosed, so you're probably going to have another hearing anyway. No?
If we decided not to wait, the motion would be to either or approve the Attorney General's motion to quash.
Yeah, the motion is to quash the subpoena, so if you move to grant the motion, then the subpoena is quashed. As to here, that would not affect the Superior Court case.
I'd be inclined to wait until the motion was decided upon in early December, get an actual judge's opinion.
If you were to do that, the motion would be to continue the hearing on this matter to the same date that we have for the Attorney General to review the documents that were disclosed to them today for the prior motion.
I'd make that motion that we continue it until a future date mentioned.
There a second?
I'll second, but also I'd like to ask a question. Is there any possibility that there's some difference in that information? Ones that would be produced with the upper request and.
There is, and that can be addressed at the continued hearing.
Any further discussion? Oh, all the subcommittee, Mr. Gagnon,
Aye.
Ms. Reynolds?
Aye.
I too vote aye.
Thank you.
So, we've done the pretrial motions. And you've got continued hearings. Probably a good idea to let the lawyers that are here know when this will be addressed. If I can make a recommendation, if these matters be continued to the second meeting in December, that'll give Judge Respallo plenty of time to not only hear, but perhaps even when
We don't have a second in December.
You don't? Oh, okay, well,
Merry Christmas.
Yeah, there's a holiday there.
wow. Well, do you want to continue it to the first meeting in December, see how things are?
Might be away.
But he said he's gonna be away.
Okay, do you want to continue these matters to the January meeting, first January? Do we have 2 meetings in January? The first meeting in January?
Okay, that's fine. I mean,
Okay with me.
we need that
It's okay with me.
motion. We can,
I think you do, yes.
all right, someone wanna make that motion, please?
Continue the next hearing will be in January.
Yes.
Meeting will be first meeting of January.
For a second,
Second,
Now, it's not on the agenda. We, of course, we have someone here for the Attorney General's Department. We have to observe the Open Meetings Act. Council should start thinking about when we can start scheduling these for the hearings on the main issue.
I guess I would like some guidance on how the subcommittee wants to go about hearings. Will they be held in Washington County? Will they start in the morning? Logistical matters.
we have a motion. It's been made and seconded to continue this. Can we vote on that and still continue discussing?
I'd say vote on the motion first and then we'll have a quick discussion, which is not on the agenda, but we'll skirt around.
All right,
Because it's
Mr.
scheduled.
Gagnon,
Aye.
Ms. Reynolds,
aye.
I too vote aye.
We'll take up those scheduling matters at a future date, including the structure of the hearings, and we'll discuss that with you all, where the location will be. I will say that it's been the past practice of the board, of this subcommittee, to have the hearings in the community where the right-of-way exists.
Sure. I'm just looking to have this dialogue about logistics so we can plan for how many witnesses we could fit in a day and so on and so forth.
That's correct, and we'll address those matters when it's posted so that the public knows what we're talking about.
Understood. Thank you.
If I may, I know you just mentioned, Council, that you'll be addressing scheduling matters at a later meeting, but if I may inform the Council and parties now, I'll be filing my court excuses this week. I haven't done it yet, but I've been scheduled for surgery the first week in February. I expect the first week and the second week to be unavailable and available before and after that.
We'll accommodate that.
Thank you.
Anything else to come before us?
I just had
Yes.
2 other administrative matters. At our last hearing, motions were granted for the council to issue subpoenas to Save the Bay and Matthew Ferraro, an individual. I just wanted to follow up on the status of those subpoenae so that we can follow up with both of those parties.
Please prepare the form that you find acceptable.
Okay,
I'll review them and then they'll be issued by the executive director.
okay. Thank you very much.
Anything?
That's it, right?
All right. I will entertain a motion to adjourn.
So moved,
Second.
Motion made and seconded. Any discussion? All in favor, say aye.
aye.
Aye. Anyone opposed? Matter is adjourned.
Thank you all very much. Excellent arguments.
Thank you, Attorney Assistant. For the subcommittee.